rise. The Court of Appeals Division 1 is now in session. Thank you. Please be seated. Good morning. We're here for oral argument in case number 1, CAUB 21-0107, Barriga versus ADES/Precision. These proceedings are being video and audio recorded, so we ask counsel to please identify yourselves and your client at the beginning of your argument. Each side will have 20 minutes. Appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal if desired. Also, we've read the briefs and have discussed this case in conference. Counsel, you may proceed.
Good morning. My name is Kate Myers, and I represent the appellant, Mr. Pedro Barriga. In our briefing, we established entitlement to benefits under 2 separate grounds, but for purposes of this presentation, I'm going to focus on the first ground. I'm happy to take questions from the panel on either of the grounds raised in our briefing. For nearly 90 years, Arizona has protected workers unemployed through no fault of their own from the crushing weight of unemployment. Despite this, it appears ADES has been applying an interpretation of one of its regulations that excludes broad swaths of Arizona's workforce from eligibility for benefits. This interpretation seems to be based on one case, Murray v. ADES. The case presently before this court gives this panel the opportunity to review Murray's interpretation, clarify the burden of proof under the regulation in question, which is Code Section R6350515C, and to ensure that Mr. Barriga receives the benefits to which he's shown entitlement under the statutory and regulatory text. I'll start first with this court should do this for three reasons.
Counsel,
First,
before you get to those reasons, what's the remedy you're seeking from this court?
we seek this court to review Murray and to reinterpret 50515C because the principles underlying stare decisis don't weigh against revisiting Murray. The reasons I was going to state are these same factors. First, that Murray's interpretation is not consistent with the statutory or regulatory text. Second, that the interpretation undermines rather than furthers the statutory scheme. And also that Mr. Barriga has shown that he was subjected to an intolerable work situation due to an inharmonious relationship with a fellow employee.
And if we agree with you on Murray, what is the remedy then? Does this court make a benefits determination, or does it remand to the appeals tribunal or the appeals board?
I think this court has discretion to either remand for further proceedings and additional factual findings if it finds that the facts aren't sufficient, the record is insufficient. But I also think that this court has discretion to clarify that standard and, as I said, remand under that standard for further proceedings. When we look at the text, which is what I'd like to discuss first, of the regulatory and statutory scheme, the Employment Security Act basically sets forth a 2-step process for benefits. First, the claimant has to establish entitlement to benefits, and second, ADES has to determine whether that claimant has met his or her burden. If you look at the text of 50515C, it has 2 main subsections, 1 and 2. And even though it's written in passive voice, the verb usage is instructive. Subsection 1 says a worker who leaves with good cause if it is established. That use of established refers to the claimant's burden of establishing entitlement. So this first section refers to the claimant's burden. The second section, on the other hand, says in determining whether a situation is intolerable, the following factors shall be considered. Because ADES is the entity making the determination, this subsection goes towards ADES's deliberative process. And when we look at that subsection, the language used shows that subsection 2, A and B, sets forth a non-exhaustive list of factors for the tribunal to consider. It uses the words factors, should, and consider. Factors means elements that come together to reach a conclusion. Consider means to think about. And should is a discretionary word as opposed to shall or must. You'll also notice in subsection 2 there's no limiting language such as only, should only consider. And when you look at the two subsections A and B, there's no word in between indicating whether these are both required to be shown, whether either is required to be shown. So that language indicates to me that this subsection sets forth a non-exhaustive list of factors. This interpretation would not only be consistent with the structure and the language used, but it would lead to a consistent interpretation of similar wording and phrases throughout the regulatory and statutory scheme. The words factors shall or should and consider appear multiple times in the text. For example, ARS 23776 says, in determining whether or not work is suitable for an individual, the department shall consider. In 1977, this court, and then in 1980, the Supreme Court held that that subsection sets forth a non-exhaustive list of factors to be considered. So interpreting this subsection 2A and B as a non-exhaustive list would allow for consistent interpretation throughout the scheme. So that's the language, that's the text. The second thing I'd like to talk about is the underlying purpose of the Employment Security Act. In a lot of instances, it's really hard to determine what a body's intent or purpose is when passing a statute or a regulation. But in this case, the legislature spoke clearly and unambiguously. The very first section of the Employment Security Act says that the act is designed not only to relieve the crushing weight of unemployment from the worker and his or her family, but also the societal impact of unemployment. The Arizona courts that have interpreted this language have said that the act is remedial legislation that should be construed broadly. Both the facts and the law should be construed liberally in favor of finding benefits and narrowly against denying benefits. So if we interpret this broadly, it furthers that purpose. It simply cannot be in a state as diverse with such a huge workforce as Arizona that the only two grounds set forth in Murray are the only two circumstances that can be eligible for benefits.
Counsel, what if the regulation instead said the following factors and no others shall be considered? What would your argument be?
That would be a much clearer statement of intent that this is a limited list and that both must be considered. But that isn't there. There's no limiting language.
It isn't, and that's a hypothetical. What the factors under your reading of 2 could be considered? Is there any boundary, anything that's off limit under your reading?
Well, I think that the first section clarifies the burden, and it says that the worker must establish who leaves because of inharmonious relations with an employee, so that's one element that needs to be included. And then it says, if it is established the conditions were so unpleasant that remaining at work would create an intolerable work situation for him. Now that burden is defined throughout within the regulations. It's a reasonable person standard. It's what would another...
And I understand that.
Yes.
Really what I'm focusing on, because your dichotomy, number 1 is the employee's sort of burden, and number 2 is the ADES's process.
Right.
And since we're here to talk about 2, what is there, should ADES have to consider any and all factors that might arguably apply, or what list would they have that they'd need to look at?
I think, and I know we said not to talk about 1, but I think number 1 illustrates, because it says the conditions. That to me indicates a totality of the circumstances approach. And then ADES also has rulemaking authority, so if it finds that this is too expansive of an interpretation, it can go through that process and limit it. But I think that these 2 factors are being construed so narrowly that it would exclude huge classes of workers. For example, say you're getting sexually harassed. It's not covered by these 2 if there's no physical violence or curse words or verbal abuse. Say your coworker is slashing your tires. Not covered, but harassment, it's an intolerable work situation due to an inharmonious relation with an employee. So I think that can be further defined by the agency if it wants to limit those factors. But under the language as it stands, it's quite broadly worded, and in accordance with the policy provisions of the statutory text, I think that these should be construed liberally in favor of granting benefits. So that's the purpose aspect, and I'd like to next turn to Mr. Barriga's factual showings.
Before you go down that road, but speaking about the facts, it seems to me that both you and the opposing counsel have acknowledged or suggested to us that ARS 12910F is applicable here. And from my reading of the statute, it seems like that might be incorrect, but I'd like to know I'd like to know how far you're willing to push that, or how hard you're willing to push that concept, given that it seems like mostly you're arguing the legal question here.
Absolutely.
And so I guess two thoughts. Do we need to address whether ARS 910F applies here? Because I'm assuming we remand, if we remand, or is that something does that really have to be addressed, or can we kick that can down the road? And if we do address it, why is it that it applies here if this is a separate procedure that the legislature set up to come directly to this court and not to the Superior Court, like most administrative appeals would go directly to Superior Court first? So I know that's a long-winded question, but you get the flavor of that?
Yes, and I'll admit, when I first was reviewing these facts in this law, I had many questions about 12910. It's fairly recently amended. I think it was April of last year. There have really only been 4 cases that have discussed it, and previous to our briefing, there was only 1 case that discussed it, and it didn't really get into the deference to the factual findings. So it was a little unclear to me initially how this would apply, but when you see it says when after reviewing the administrative record and supplementing evidence, the court may affirm, reverse, modify, or vacate. That goes back to Judge Thumma's question earlier. And then later it says, in a proceeding brought by or against the regulated party, the court shall decide all questions of law, including interpretations of rules adopted by an agency without deference. So I think in this case, when we have, and also that's the factual findings as well. So in this case, there are several conflicting factual findings at the different levels of review. The first level of review, I believe they said that Mr. Barriga didn't attempt to adjust his grievance. And then the second level of review said he did attempt to adjust his grievance. And then the third, he didn't. So if this is a de novo review, this court can sit as fact finder and review the record de novo, resolve any sort of credibility determinations and as to weight. And I think that because this is an administrative proceeding, it appears to me that that section would apply.
Counsel, let me ask you, your focus is in response to Judge Brown's question on 910F. But 910F is part of a section, 910, which is part of a larger group of sections that don't fit very well for administrative appeals that come straight to this court. For example, 910E, the record in the Superior Court shall consist of the record of the administrative proceeding and the record of any evidentiary hearing or the record of the trial de novo. 910A talks about receiving testimony and argument, things that this court either is not or doesn't do. So let me follow up again with Judge Brown's question. I get your focus on F, but it seems to me in a larger sense there's a genuine question about whether 910 and its sibling statutes apply at all to administrative appeals that come directly to this court.
And that is a wrinkle I'd not fully think through, but I think that it makes sense that there would be a different standard for appeals coming to this court than from the Superior Court. I just looked at this and said, after reviewing the administrative record, and I figured this is administrative review, this is a judicial review of an administrative decision, so regardless of whether it's the Superior Court that's doing that review or this court that's doing the review, it seems to me that the Superior Court would in essence be sitting as a sort of reviewing appellate court anyways, and so it would similarly in that posture not have the ability to take additional evidence, except that it's specifically allowed to do so. I think that my understanding is that this court follows the rules of appellate procedure in this review. Under that, this court can vacate and remand, as I mentioned earlier, and that upon that level of review, maybe then there would be able to be new factual findings and the parties could submit additional evidence or argument. So I'm not entirely confident that this applies, but if it does, I think that it entitles this court to review the entire record de novo. And I'll just quickly summarize the facts because I would like to save some time for rebuttal. Mr. Barriga showed that he was subject to an intolerable work situation due to an inharmonious relation with an employee.
Let me stop you for a second because I want to make sure that I picked up on your answer. So if it does not apply, then your position is that the matter is remanded to the appeals tribunal or the appeals board?
My understanding is that it would be the appeals board, because the board under the scheme has the discretion to take the evidence that's been established in the tribunal level and then to accept additional evidence or take additional argument if it would like to. So it seems to me that it would go back to the board rather than the very bottom of the entire process, but I'm not entirely clear on that point. Regardless, I think that if it were remanded, there would be either at the tribunal level or the board level the ability to take additional evidence if the record is insufficient to make a determination of eligibility on this record. As I said, the facts Mr. Barriga showed he was exposed to an intolerable work situation. There's evidence in the record he started in mid-February when ostensibly it was a little cooler outside. He told his employer repeatedly about his health condition. He tried to fix the situation by working with, trying to get the cooler moved to his location. He tried to talk to his boss repeatedly to fix the situation. And as the time went by and it got hotter and hotter, it's already in the 90s in mid-April. Mr. Barriga waited until mid-May, which is quite hot. And even the employer said that with the coolers in their proper place, it was 85 degrees in that room. These workers were doing manual labor in an 85-degree room optimally. I can only imagine that when these coolers are not in the place where they're supposed to be, it would be even hotter than that in this body shop in mid-May. So I think that that's the burden of proof is sort of similar to a preponderance of the evidence. Just you have to present enough evidence to show that the matter is more likely than not true, and anything that's been established that isn't contradicted is proven. Mr. Barriga showed that he had this health problem. He testified that he told his employer about it and tried to fix it over the course of 3 months. And then once it got too hot, he had to leave. A reasonable person in that circumstance with that health condition would have to leave also. This is precisely what the Employment Security Act was designed for. I'd like to save the rest of my time for rebuttal, but if the panel has any further questions, I'm happy to answer them.
All right, thank you, counsel.
Thanks.
Good morning. May it please the court, I'm Tom Jost and I represent the Department of Economic Security. The dispositive question here is whether Mr. Barriga established that he had good cause to quit his job. He did not. So a claimant is disqualified from benefits if he left the work voluntarily without good cause. The statutes do not establish what good cause means, but the regulations do. And in part, in inharmonious relations with another employee, under 505A4, before he's entitled to establish good cause, he has to show that he attempted to adjust his grievance. And under subsection F, that applies equally to management as it does other employees. The problem that Mr. Barriga had was that he believed his manager was discriminating against him and in favor of another employee. And he never took that grievance to Precision's owner to try and adjust it. Therefore, he has not even met the prerequisite to establish good cause or compelling personal reasons.
Counsel, how far up the food chain do you have to go to attempt to adjust a grievance? Is the law clear on that? I mean, what if you have a large company with multi-levels of management? Mm-hmm. You have to go clear to the top?
Ostensibly in something like that, there would be an HR that you would work through. The record in this case, however, shows that there was just two people above him. There was the shop manager and then Precision's owner. Precision's owner testified he was in the shop regularly, he had an open door policy with his employees, but that Mr. Barriga had never come to him with anything. They had barely said more than hello to each other. And so for that reason, he doesn't even get to the good cause or compelling personal reason, because he simply failed to go to the owner to say, hey, the shop manager is discriminating against me. I have these needs. The manager isn't taking care of it. Can you do something? And he deprived Precision of essentially heading this issue off well before we get here.
What's your best case for that requirement, the case decision for that requirement?
I do not have a case applying something in these circumstances. That's just going to be under the reading of 505.15A4 and F, as far as good cause for inharmonious work relations.
So if there was perhaps a language barrier that prevented Mr. Barriga from speaking directly with the owner, is that something that should be taken into account in determining how far up the chain he gets? If he can communicate with his supervisor, would that be enough?
Well, he did communicate with his supervisor ostensibly through the third employee, who was translating both for the shop manager and the African-American employee. So the facts of this case would suggest that he would have had no problem taking that other employee to the owner, so that there wouldn't have been that kind of language barrier, because it wasn't an issue with the manager, so there's no reason to believe it would have been an issue with the owner either.
There were no findings on that point, though, correct?
As far as what the ALJ said, no. And the
appeals tribunal accepted whole cloth the facts as found by the appeals board, correct? I'm sorry,
Other way
I
around,
reversed
but
that, I
yes,
apologize, yeah.
Yeah. But the record establishes that never happened. And so the legal conclusion that the appeals board came to was that Mr. Barriga had failed to establish good cause for inharmonious work relations, and that's well supported by the record here.
That was because he didn't demonstrate one of the two factors?
That was because he didn't even get to C. He didn't pass A4, so C kind of becomes irrelevant at that point. But nor did he establish C. He did not establish an intolerable work situation either.
All right, so can you talk to us about what happens, assuming he had established it, where we go from there?
That he had established that there was an intolerable work situation?
Yes, by communicating with the supervisor.
Well, if he had established that, then ostensibly that would be a good cause to quit.
I'm sorry, that he had established that he gave the employer an opportunity to adjust the grievance, that he raised the issue with his supervisor from that point.
Okay. Then at that point, he would have to show that his relationship with the supervisor, with the shop manager, was what was creating the intolerable work situation. And there's no evidence that he did that. The shop manager had tried to work with him and the other employee to fix the situation. However, the other employee and Mr. Barriga himself both ignored what the shop manager said and continued each pointing the swamp cooler at their own respective workstation, even though the shop manager had told them not to. So that doesn't establish anything above mere distaste, dislike, or inconvenience in the working conditions. It does not rise to the level of an intolerable work situation.
So the fellow employee, from your perspective, had to be the supervisor, couldn't it be the coworker?
Well, it started as a coworker, and Mr. Barriga appropriately went to the shop manager to try and adjust that situation. That didn't work out, but he said when he quit, the reason he said that he quit was because the shop manager was discriminating against him. So by his own admission, that was the issue that caused him to quit.
Well, weren't the facts disputed on the quit? I mean, he testified he was fired.
He did testify as to that. The ALJ found that it was a quit, and the board adopted that, and he has, even in this court, not gone back to...
And I understand that, but is it your argument that the fellow employee under the reg, to use the terms of the reg, had to be the supervisor and only the supervisor, not the coworker?
Under the facts of this situation, it was the supervisor. So if this was something where he had never gone to the shop manager and it was simply this going back and forth with he and the other employee, well, then that would be the fellow employee if he had quit under that circumstance, but that's not what happened here. He, in fact, did go to his shop manager and then said, well, the shop manager isn't actually helping me, he's discriminating against me, and that was the reason he stated that he quit.
So if and let me use the word irritant, right, as a shorthand, if the irritant is a coworker and there's no satisfaction in discussion with the coworker, and then there's also no satisfaction with discussion with the supervisor, the fellow employee is only the supervisor? Is that your position, how this regulation works?
That would be, I think, what subsection F says, that you treat a manager as you would any other employee. And so he appropriately went to the first level and tried to get that resolved. And then he said that it was the discrimination not getting that resolved that was really the problem. And so in that case, a fair reading of subsection F would say that's the fellow employee in that circumstance would be the shop manager.
And just to clarify, because I want to make sure we're not talking around each other, there can be one but only one fellow employee in that context as opposed to two or more?
I suppose there could be. Depending on, I mean, there's all sorts of circumstances. If you had several employees, ganging up on one other employee, that could be a situation, but that doesn't seem to be what happened here. So that the shop manager did try to mediate the situation, told them both, hey, don't point this at your own workstation, point it out at the shop generally to keep us all cool. And it was that Mr. Barriga had a problem with.
And you have heard our questions of appellant's counsel with respect to the propriety of Murray. If we get to that point, and I get that your view is we shouldn't, but help us understand your position better about whether Murray properly construes the regulation.
Well, again, we need not reach that issue. And also, if this court does want to reach that issue, I think there are two important things to point out. Is first of all, because we think it doesn't apply, if this court did issue an opinion disavowing Murray, that would arguably be dicta. And second of all, because of the way the courts work, it would simply be disagreeing, and then there would be a conflict between Murray and whatever opinion this court will want to issue now. That would not actually overrule Murray. It would have to go up to the fourth floor for the Supreme Court to choose one or the other.
And that's the second part of that is a function of how our court works. The first part of that depends on your view of the facts.
Sure.
But tell us, and perhaps you're not here to defend Murray, but tell us, if you are, why Murray properly states the law as opposed to what appellants have argued or appellant has argued the law should be.
Well, Murray is, it's if you just go by the plain reading of the regulation, those are factors to consider. But again, this is not a case where that's going to be applicable because if you just look at the subsection.
I understand your position. What I'm trying to ask you is whether you're supporting Murray or not, whether you think Murray got the law right.
Our position is this court's prerogative to disagree with Murray if it so chooses.
And I understand that. But what I'd really like is your perspective on whether your client believes that Murray is correct law, or whether there could be other factors that are not listed in the two subparts of that regulation that would be instructive and properly considered by your client.
There certainly can be situations where that occurs, and if we look at subsection 1, just talking about an intolerable work situation, as we said in the briefing, there may be times where there's no extreme verbal abuse or profanity or physical altercation, but that the work situation is nonetheless intolerable. And there's nothing in subsection 2 that requires ADES to consider only those factors. So subsection 1 says intolerable work situation. Subsection 2 creates, it doesn't necessarily restrict ADES from considering other things.
Let me play that back and see if I understand you correctly. That 2 list factors, not elements, right, in it, because it uses the word factors among other things.
Yeah.
And the 2 factors that are listed, or at least A and B, are not exclusive.
There's nothing, there's no language in there that requires them to be exclusive. And so a fair reading of both subsections together would be that there probably is some room in there for an intolerable work situation that doesn't necessarily meet the requirements of 2.
Counsel, I'd like you to circle all the way back to where you started about the grievance issue, failure to adjust the grievance. I maybe glossed over it too quickly, but or missed it, but I'm not, where do you see that in the appeals board decision, that was the ground for denying benefits, for reversing the ALJ, that the failure to adjust the grievance with the owner?
Well, it was the failure to establish good cause.
Okay, but but you're agreeing with me that that's not in there. There's no analysis of a failure to adjust a grievance, per se, in the ruling.
Mm-hmm. And it is a short ruling, but...
So what's your theory for that? Are you saying that we're supposed to affirm the board for any reason that supports the record, like we do with the Superior Court? Is that even a thing in unemployment law?
Well, substantial evidence would support that interpretation. And if this court is going to do look at a legal de novo review, that certainly would be a basis supported by substantial evidence in the record on which to affirm the appeals board's decision. And not only that, if we go take another step towards the intolerable work situation, Mr. Barriga never established that either.
But we don't go looking for theories on which to, generally we don't in these types of cases. We read the record, we read the ALJ's decision, we read the appeals board decision, we make a decision best we can on those two documents as well as the entire record. So, I mean, I don't know, I wonder if you have any authority that suggests we go outside those
Again, like I said,
things.
if it's legally a de novo review, that would certainly be acceptable. Is that this court, even before the legislature changed 12.910, this court sitting as a reviewer of administrative proceedings was able to do a de novo review of all legal holdings based on the record.
Counsel, as a follow-up to that, help us better understand your argument that 12.910 applies.
I think the best argument for that is I don't know of an alternative. As you know, I haven't done a thorough reading of Title 12, but as far as I understand, there is no special statute for this court to review UBs and IC cases, which, as I understand, are the two that come straight from the agency to this court.
And let me ask you on that, I'm paraphrasing or reading from 1993B. Any party aggrieved by a decision, the appeals board may file an application for appeal to the Court of Appeals?
Yes.
For 910 to apply, 12.910 to apply, it has to come through the Judicial Review of Administrative Decision Act, which says, hey, that covers agency actions unless a separate act provides for judicial review of the agency decisions and prescribes a definite procedure for the review. Isn't Title 41, the statute, just such a separate statute?
The question there is whether it provides a definite procedure for review. And in that case, if we're going to rely on 41-1993, what then is the standard of review? You know, 1993 does not establish a standard of review, whether that's de novo, substantial evidence, what have you. So then the court, obviously the standard of review is procedural and doesn't necessarily need to be, or sometimes may not even be, set by statute. So as a procedural issue, that would be something that this court could do under 1993. But as far as my reading of 1993, it doesn't set a definitive procedure for how that is supposed to work.
Is your argument then, because there's a set of rules, Judicial Review of Administrative Decision, JRAD sometimes, as opposed to JRAD-A, which is a statute, right? But it's not your argument that JRAD, the rule set, apply here, is it?
No, that would be unworkable, and I get that this court is concerned about 12.910 and the fact that it's kind of a square peg in a round hole, is that statute was definitely meant for the Superior Court sitting as JRAD and was not tailored to this court. So that is definitely going to be an issue for this court. But as far as anything that sets a procedure for how that's supposed to work at this court, 12.910 is the closest we have. So
even though portions of 12.910 wouldn't apply at all to this court?
That's true, because this court simply doesn't have the ability to take testimony,
Right.
evidence, and things like that. And certainly, if we're going to be talking about 12-910 and 41-1993, if this court would like supplemental briefing on the issue, we would be more than happy to do that for you.
Appreciate that. We just, both parties have said 910 applied, and we've struggled with that.
Yeah, understandably. You're not the only panel of this court to struggle with 12-910F.
Well, and to me, it's broader even than F. It's really the whole cluster of statutes at the beginning of the 900 series in Title 12.
Yeah, and 41-1993 certainly would bear on that discussion, but, as we haven't briefed that, and it wasn't raised, to really get at any answers of it, I'd be a lot more comfortable to do supplemental briefing than to try to give you, anything firm right here. And going off of 41-1993, as far as the injury or illness, this court lacks jurisdiction under that statute to address the injury or illness argument because it wasn't raised in the petition for review to the appeals board.
And that petition was from a favorable determination by the appeal tribunal, right?
Mm-hmm.
And that petition was filed by your client, or by the employer,
By Precision,
actually.
yeah, the employer.
How would our appellant here, Mr. Barriga, have raised that, given that he wasn't harmed by the appeal tribunal decision? He liked the appeal tribunal decision. He sought no petition, nor would he have any reason to. He was not an aggrieved party.
Mm-hmm. And that's just kind of the language of 1993 is in the passive voice. It doesn't say, an aggrieved party who files a petition for review may not raise other things. It says no issue that was not in the petition for review may be raised on appeal. So maybe that's kind of a harsh outcome, but that's the language the legislature used, is the passive voice, that if it's not in that PFR, it cannot be considered on appeal. And that's going to be a jurisdictional bar.
Yeah, but why wouldn't that only apply to the petitioner? I mean, why would it apply to the non-petitioner?
That's a good question for the legislature. I'm not sure. But, the plain reading of that sentence is the passive voice, that if it was not an issue raised in that PFR, it cannot be raised on appeal here. That may be a harsh outcome. I understand if that is not the most comfortable thing in the world, but it is a jurisdictional bar, and the legislature has seen fit to write that in the passive voice. So there's not a lot farther we can go.
Is there any case law that you're aware of supporting that?
The only case law that we've seen on it, we cited in our brief, and that would be holding it against the petitioner. I'm not aware of any case applying that against a non-petitioner. And as far as that goes, if this court does find that it has jurisdiction over that issue, well, nobody ever got a chance to rule on it. The deputy didn't rule on it. He raised it. The ALJ only had, a little bit of testimony on it, and the appeals board didn't rule on that. So as far as going back to the remedy, if we're talking about the injury or illness, the appropriate remedy there would be vacator and remand to the deputy for an initial determination of his injury or illness and whether he was able to work. I see that my time is up, so if this court has no further questions, thank you very much for your time.
Thank you, counsel.
I'd like to make a few quick points in rebuttal. As to the attempt to adjust grievances, Mr. Barriga, three representatives of the employer testified. All three of them admitted that Mr. Barriga had told them about the problem, that they were aware of it. It's both shop manager, the office manager, and the owner himself. In terms of the discrimination aspect, I think that the testimony and the findings of the board and the tribunal show that this discrimination was based on the way that this other employee was treated, including the failure to adjust the cooler. If you look at Index 143 of 50, it says, Mr. Barriga says, I told him he should take care of the issue with the cooler because I needed it due to my illness. If you look at the employer's testimony, I believe that it was Mr. Holm, it might have been Mr. Berry. They both said that the discrimination was due to the cooler situation, at least in part. But again, that would fall under my proffered totality of the circumstances approach. And then finally, even if we don't, I think that 910F applies based on the language of 910F. If you look at the language of 910F, the last sentence says, notwithstanding any other law, this subsection applies in any action for judicial review of an agency action that is authorized by law. And it also talks about in a proceeding brought by or against a regulated party, the employer brought the appeal, so it's a regulated party. And then finally, even if we don't apply 910F, the findings are sufficient to support an award of benefits because the appeal board adopted all of the appeal board's or all the appeal tribunal's findings. Those findings include that the place became extremely warm, that the other employee was goading him, that he, after a number of discussions, claimant tried to express his frustration to his supervisor with the situation and believed he was being ignored. Those are all adopted. These are not overturned. If you look at the board's decision itself, it says they find no material error in the findings of fact, and we adopt them as our own. We find the reasoning, however, to be an error. And when you turn a couple pages later on page 4, it says, we disagree with the tribunal's reasoning. To establish good cause for quitting, a claimant must show that the relations were so unpleasant that remaining at work would create an intolerable work situation. When determining what circumstances constitute that situation, the rules state that factors to consider are whether the situation would cause severe nervous strain or a physical altercation, or whether the use of extreme verbal abuse or profanity was involved. So the appeals board completely accepted the appeals tribunal's factual findings whole cloth and simply disagreed on the interpretation of 50515C to A and B. Thank you.
Thank you, counsel. This matter is now taken under advisement, and we will issue a written decision in due course. We're at recess.